Welcome to Cordell and Cordell's Men's Divorce Podcast, moderated by Managing Partner and CEO Scott Trout, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hey, welcome back to the Men's Divorce Podcast. I'm Scott Trout, Managing Partner and CEO of Cordell and Cordell. And we're going to talk to you today about a topic that is so relevant. It's really child support and alimony. What is it? How does it work? And obviously across the country, it's different in every state, but there's some common issues and strategies that relates to both of them and the mysteries surrounding how they're calculated, because I get that all the time. I have questions about child support. I have questions about alimony. And so we're joined today, thankfully, from Kevin in Alpharetta, Georgia. Welcome.
Thank you, Scott. I'm glad to be here. So ready to talk about child support and alimony, and I can address it from the perspective of Georgia. I do think that it's probably fairly similar across some of the states. Obviously, it's not exactly the same. So it could be vastly different in some states, and some states it's pretty similar. But so just to jump into it. So child support and alimony obviously are both forms of support. Child support is for the children. Alimony is financial support for a spouse. Child support obviously is usually in the form of a monthly payment, and we'll address how that is usually calculated or strictly calculated in Georgia. Alimony is usually in the form of a set monthly payment for a fixed number of months or years, but it can also be in other forms like a lump sum alimony or payments sort of in kind for other things like a car payment or a mortgage to a home.
Yeah, you talk about child support alimony. If there, that's the kind of word we used to use a lot. A lot of states still use it. It's spousal support, maintenance, whatever. It's common words. But child support, the common question I get is, look, I take care of my kid. I pay for this, I pay for that. Why am I paying more? Isn't that part of child support? So there are other forms of child support. So what would you expect to see as other forms of support that would normally a guy or a mom or would be paying?
All right. So in Georgia, we'll have a set child support amount. Other forms of child support that are required to be addressed by the court are work-related child care expenses and uninsured medical expenses. And then there's other parameters or other issues that could be addressed by the court potentially, like extracurricular activities. So work-related child care expenses, it is a requirement that those are addressed if they do exist. So in addition to child support, the parties may have to share to some degree in work-related child care expenses, medical insurance premiums as well. One party's probably going to be responsible for payment of those. But that would be an adjustment to the child support obligation. So the amount that someone pays for medical insurance premium will be factored into the child support calculation. And then extracurricular activities, that's the situation where, most times you'll see parents, I think, even though they're getting divorced, they'll often agree as to what they want their children to participate in. They usually don't want the children to not participate in it, even though they're getting divorced. So you'll often see agreements where the parties agree to share certain expenses related to their kids' activities. And if the parties don't agree, the court does have the discretion to put those factors or those costs into the child support calculator. And they could either increase or decrease the child support obligation depending upon who's paying for those expenses.
I think child support, for the most part, is, maybe the more common thing. And then the mystery is in alimony. Well, what is it? How is it calculated? And, there are different forms. And even in Missouri, where I practice primarily, even though I'm licensed in Missouri, Illinois, and Georgia, we have lump sum, we have periodic, we have modifiable, we have non-modifiable. Okay. It can take all types of forms, right?
Yes. So in Georgia, we have pretty much all those forms. The most common form that you'll see is just a monthly payment for a fixed number of months or years. We do have lump sum alimony. In Georgia, if you do agree to pay lump sum alimony, and this is very important, that is non-modifiable. And the reason I say it's very important, I have come across some of our clients or potential clients who were divorced previously, and they either did it on their own or they did it with an attorney that maybe didn't explain it to them. And I have seen this happen where they've agreed to a lump sum or a fixed amount of funds over a number of years, and it was not modifiable. So it's very important that, at least in Georgia, the terms are explained to the person that's agreeing to pay alimony so they understand whether it's modifiable or not. So that's a big factor in Georgia that's really important to take a look at.
And we'll talk a little bit about the calculation, the methods. So let's talk about child support because it is a hot topic about, one, either disagreeing with how it's calculated, but more importantly, how is it in Georgia? How is child support calculated? Is it formulaic? What does the court consider?
Sure. So it is definitely formulaic, and the court is required to go by the child support guidelines. So we can usually predict with a decent amount of certainty what the child support obligation will be in Georgia because of the calculator. Whereas with alimony, it's very discretionary with the court. The primary factors for calculation of child support in Georgia are going to be both parties' gross incomes, not net incomes, just actual gross monthly incomes. And then it would be medical insurance premiums and the issue of work-related childcare expenses. So those four factors, if you include the mother's income, the father's income, medical insurance premiums, and the childcare expenses. You have those factors, and you could pretty much determine with a reasonable certainty what the child support obligation will be.
So in Missouri, we have what we call a Form 14, and that is kind of this spreadsheet we use to calculate. And likewise, we use gross income. And at the very bottom, after we do certain things, it says presumed child support amount. Okay. It's an interesting word because it is presumed. It's not absolute. It's not definitive. We have the ability to deviate through a number of things. It could be number of overnights. It could be that we have this catch-all phrase that the number is unjust and inappropriate, period. And then the court really has wide discretion here in Missouri to determine whether or not it needs to go up or go down. Can you do that in Georgia?
Well, actually, everything you just said sounds extremely similar to our statute. So we have those same words, unjust and inappropriate. We have a presumptive amount of child support. So the factors that I just mentioned before, the incomes, work-related childcare expenses, and medical insurance premiums, those factors, you will arrive to the presumptive amount of child support, and then the judge does have the discretion to deviate from the presumptive amount based on a whole number of different factors. The only ones that I usually see that really pop up: private school education, extracurricular activity expenses, and parenting time deviations. Yeah. Those are primarily the ones that you'll usually see. So that is completely discretionary with the judge. Some of the things they'll look at, certainly with private school, is, did the child or the children, have they historically gone to private school? And the reality is, in a divorcing family with two households now, sometimes the reality is that maybe it's not affordable. So, it depends on what your client desires to have happen here. But there are times where it can't happen because there's not enough money to go around. But if there is, and the children have historically gone, there's a good chance the court may include that in the calculation for child support in Georgia.
So on the parent deviation, that's a big hot topic, obviously. Missouri eventually got to what we call a percentage line 11 adjustment. And Missouri just changed and passed a new statute that requires the court in any custody to start, period. It is presumed that equal parenting time is in the best interest of the children. So they start there, which is a really interesting new twist in the law that substantially discounts the presumed amount on an adjustment. So how does it work? Is it really subjective? Is there guidance in Georgia on how that parent deviation works?
Well, unfortunately, there is no guidance. That is something I believe when the new child support statute in 2007 was enacted, they left out. I think this legislature couldn't come to a determination as to how to apply it. It sounds like they did finally in Missouri. So in Georgia, we have the parenting time deviation, but it is all that there's no guidance in the statute. So we just have to go kind of with local practices. And we don't have a situation where we can count the number of overnights we have. But usually in a situation, if somebody does have about, I would say around anywhere from 35 to maybe 45% of the parenting time, you may be able to successfully get a parenting time deviation. And how that is applied is pretty discretionary with the courts, but we kind of have a few different ways we approach it typically to, make a good argument to get that deviation.
Right. And you judge to judge, I imagine. And you have some ideas of the judges the same what they typically go with in terms of a deviation, I imagine.
Yes, exactly. And some judges don't like it, some do like it, but there are certainly times where you can make a good argument to them, and usually they go with it. Yeah.
Any additional arguments you can make to try to drive that number either down or up, depending upon your circumstance?
Sure. So the incomes, so we can always argue what goes into the calculator, obviously, and that's where the arguments in child support come. So you could argue about the parties' respective incomes. So if you have variable incomes, so many of our clients may work in the sales industry, you're commission-based, bonus-based, heavily dependent upon those further incomes. So what we'll usually look to in those situations is if they had a great year, like I know some people had an incredible year based on the industry they're in 2020, as strange as that sounds, some people had a phenomenal year in certain industries, but that was an anomaly. So we usually go to like a 3-year average, but there are times where that doesn't say, there's nothing that says it has to be a 3-year average. So sometimes 4 years makes sense, sometimes 5 years makes sense. So what we'll do is try to look to the history of earnings for our clients and come up with a reasonable average so that their income isn't disproportionately higher than it otherwise would be, which is what I think the other side would want the court to use. So usually they'll look to a reasonable average. So we can argue what goes into the party's incomes for the child support calculator. There's not much arguments about what the medical insurance premiums are. And then obviously you could argue about whether or not deviation should go into the calculator, like extracurricular activity expenses, whether or not private schools should be continued, stuff like that.
It's interesting because a lot of lawyers, that's maybe a common complaint you see from clients that say, look, you told me that's the number, we got to pay the number. And we've always maintained, and I have always, look, I'm going to make every argument I can to deviate, whether it's up or down, depending upon what you want. And that's what the law allows us to do it. And I think being creative in that regard, the averages, I've been talking about, the economy and inflation, and now that's a good reason to deviate either upward or downward based upon the standards of living and what everything's costing. And the amount of money available is really no longer the amount of money available because income hasn't kept pace with the cost of living. It's really an interesting argument. And I'm seeing at least judges being very receptive to deviation simply because the economy and the status. So
that's a great point, actually. And that's something we've started to address this year, I'd say, with the inflation and the cost of rent being so high. So when parties are divorcing and with the mortgage interest rates as they are, if they go to get a new home, their mortgage is going to be higher than it was. Yeah. And if they go to rent, it's way higher than it used to be. So we are making arguments to the judges that there needs to be some accommodation for a reduction from the presumptive amount of child support based on the fact that they're not going to be able to actually have a decent standard of living. They don't have to have a perfect standard of living, but they have to be able to live and go to work and make income and have their kids.
The status quo is no longer available. And means that, you either bankrupt one person or you change the standard of living for both. And that's what we're arguing for the judge is, look, you can no longer rely on the calculation simply because it will bankrupt the payor spouse. Yeah. And so it's interesting. Yeah. So let's just transition to alimony, kind of go through the generalities of it, kind of, that's always the question, how long do I have to pay? Is it forever? Missouri is very different than many states. And, in terms of how is it, the term, what is it? Talk a little bit about in Georgia, what you typically see.
Sure. So we look to, at least initially for our discussions, we'll look at the term of alimony, and that just covers the length of how long you would pay alimony for. And then there's the amount. So there's nothing in the statute in Georgia that addresses how long alimony should be paid for or how you come up with the amount of alimony. So it's very discretionary with the judge, and it may vary from locality to locality. But generally speaking, in Georgia, an unwritten rule, I'd say, is that payor may pay alimony for about 1/3 the length of the marriage. So if you've been married for about 10 years, you can reasonably expect to pay about 3 or 4 years potentially of alimony. Now, it doesn't have to be that way, and there's nothing that says it's always going to be that way. But that's a general practice that you could see across the board, at least in metropolitan Atlanta. That's what we typically see, and I think that's pretty broad across Georgia as well. So that's the length of the term. Now, if you've only been married for a couple of years, it doesn't mean you're going to be paying alimony for 13 or 14 months or something like that. Usually, I don't see alimony awarded in a short-term marriage like that. Yeah. As far as the amount of alimony goes, yes, that is often a disputed hot topic. Always a point of pretty much always a point of contention at mediation, settlement discussions, and certainly a trial. And I would say that's one of the most heavily probably litigated issues out there. Parties often agree on division of property. They often can agree on what's best for their children, not always, but one issue that you don't usually see an agreement upon is alimony, at least not initially.
Yeah, it's interesting, the commonalities in Missouri. Although as progressive as it may be on child support, it seems that it hasn't made up any ground. I mean, this is my 31st year of practice, and the alimony laws haven't changed one bit. Very, very discretionary, but it's oftentimes a lifetime award, no matter what.
Oh, okay.
So I love the 1/3 of the marriage. You just won't see that. And I'll always describe to clients, same facts, same judge, given to that judge 11 times out of 10, you'll get different result. And it's crazy.
Wow.
And because it's so subjective. And that's why the lump sum, the term, and it's a lifetime open-ended modifiable maintenance award. And it's oftentimes difficult to terminate that maintenance. I had a case we went to the Supreme Court on, 6-year marriage. He'd been paying for 12 plus. Wow. And I still couldn't get it terminated. Jeez. It was crazy. So it's very, as you say, I mean, it's, very discretionary, but I like the guidance in Georgia about typically the 1/3. That at least gives clients something, some relief in that regard. Now, in terms of the amount, again, discretionary fully by the judge?
Yes, there's no calculator, unlike child support. And I've heard there are some states out there that have a calculator. And sometimes I think that will be good, but then who knows, it could be bad. But as far as how we come up with that amount, so the analysis that we usually do with our clients, at least initially, for the discussions of trying to get an idea as to what the payments could be, it's really, we're looking at a need for alimony versus an ability to pay. And I always tell my clients, we could start on either side of that analysis. It doesn't matter which side. So let's say we focused on one person's need for alimony. What we're trying to do in that situation is predict to the degree possible what their post-divorce expenses may be. Now, at least in Georgia, there's not an expectation necessarily that that alimony is going to cover every expense out there for the recipient of alimony, although there are situations where if the person can afford it, it may be. But usually what we're looking at is the big ticket items is what I refer to them as. So post-divorce, someone's definitely going to have a mortgage or rent, medical insurance premiums, auto insurance, car payment. Those are the things I look at least first, maybe utilities as well. And we try to come up with a number. Okay, if they have no income and they're living on their own with no children, what do you think they would need? Not to necessarily lead the same exact lifestyle that they've been leading, right, which is what the alimony statute does indicate that, but at least in practice, it's not exactly like that in Georgia. So we're looking for their need for alimony and what does that number look like? And then once we come up with that just general kind of number, we'll shift over to the payor side. So if I'm talking to my client, he has a potential alimony obligation. We want to see if he actually would have the ability to pay. So what we look at there is, we could start with the gross income, but then we know you have to pay taxes. You can't get out of that. So we'll take away the taxes. If you're paying child support, you can't get out of that. So we take that away. And then unlike child support, which doesn't care about, your expenses, like your day-to-day expenses, alimony does allow the court to consider all your reasonable necessary expenses. So if you have a mortgage, you have rent, you have a car payment, you need to go to work and buy clothes and eat to continue to have the same career that you have had to pay the support, the court will take all that into consideration. So we'll try to whittle down, and then theoretically, whatever is left after we reduce all those expenses and take them away is what that person would have as an ability to pay alimony. It doesn't mean they're going to pay that amount. But that's usually where we start the discussion. And at some point, you'll get to kind of I guess I would say a rubric maybe a realm of possibility of what those numbers could be. Yeah.
And that's exactly one of the mistakes men make when facing divorce. And I've said this over and over, is not paying enough attention to their initial financial disclosure. It's called something different in every state, and putting more income than expenses, meaning, and they really don't have it. Guys will say, on this document, and it shows that they've got $2,000 left over. But in reality, they're telling me, well, I don't have that. Well, you made a mistake. Pay attention to that document because the court's going to rely on it. I tried a case in Georgia many years ago, and that was the very thing that happened. The wife presented an income and expense statement or whatever it was not accurate, and it showed that she had more income. And the judge hammered her on it, and that she didn't need maintenance. So they didn't award maintenance because that was the evidence. And so it's very important. But the ability to pay is a great argument, in terms, especially now, as we discussed inflation and what that does to your ability, net income. We do the very similar approach in trying to analyze that. And so what happens when you have a spouse who wants alimony but isn't working and hasn't been doing that for a number of years?
Yes, those are certainly tougher cases. What we'll try to do in those situations, there's a couple approaches you could take. Obviously, you want to look into her background and what she has the ability to potentially earn. There's always experts that you could potentially retain or employ to analyze their ability to work. However, if those are not available, what I would say is one thing that we'll consider, at least in Georgia, is the amount of alimony does not need to be the same for the duration of the term. So it could be a certain amount for years 1 and 2, and then 3 and 4, and successively reduced down to a lowest amount towards the end of the term. So what we might do in that situation is front end a high alimony amount, which isn't ideal, but you do that for a year or two, and that would be considered rehabilitative alimony in Georgia. We don't actually have that in the statute, but that's what the judges will look at it like, to give her an opportunity to become self-supporting, and then the amount should reduce fairly significantly after a couple of years. But that is an unfortunate circumstance. Sometimes, the first year or two could be a high amount of alimony, but there should be some reduction as the years go on.
Yeah. And there's ways I've used experts of what's called a vocational rehabilitation expert, just to try and say, okay, this is what they're capable of making. They have an RN and they just haven't used it in 5 years. Can they, get back into the field? There's plenty of opportunities on that. And that's why I say all is not lost. I actually feel like I have more flexibility on an argument on alimony than I do on child support, and trying to look to lower that amount. And that it doesn't seem logical, but it is. And so interesting. Well,
I would agree with that. That's the same here, pretty much. Yeah.
Well, good. Kevin, thank you so much for a great, quick snapshot update on child support and alimony. We could keep going for another hour and dig right into it. Maybe another time for a virtual town hall. So thanks for joining Alpharetta, Georgia. Appreciate it.
All right. You're welcome. Thank you, Scott, for having me. I appreciate it.
We'll continue to tune in, check out iTunes, check out our YouTube channel, and give us a call, 866-DADS-LAW, or find us on the web at CordellCordell.com. You can go to your office by doing just a search and where the closest office to you is by putting in your address or zip code. Or if you want to schedule a consultation, which is the only place you can get legal advice, can't do that here, too general. You can go to the Schedule Now button that is sitting on our website. Just find your office, find a time that's convenient for you. You can do it in person, on the phone, Zoom, WebEx, whatever's convenient for you. That's at CordellCordell.com. So stay tuned. Look for the next virtual town hall where you can log in live, ask questions of a panel of Cordell attorneys, and get answers right then and right there. Check us out on all the social media, Facebook and Instagram. And until next time, have a great week.